A little more than 3 years ago, a majority of the justices in the Supreme Court overturned the landmark Roe v. Wade with their decision in the Dobbs case. Here in Georgia, that ruling opened the door to a Republican-backed law known as the Life Act that is often referred to as the heartbeat bill because it bans most abortions after a fetal heartbeat is detected. We sit down with one of its primary sponsors, Republican State Senator Ed Setzler, in this week's Sunday Conversation. You sponsored, and really you were a key sponsor of Georgia's heartbeat bill. Why?
You know, the Living Infants Fairness and Equality Act recognizes the very difficult circumstances women find themselves in with unplanned pregnancies, but seeks to balance that with the basic right to life of a living, distinct human child growing inside of mom. And I think as we try to strike that balance, we're informed that the 49 years of brutality, the violence of Roe versus Wade, where 62 million living, distinct lives were taken in 49 years, where 7 justices imposed on our legal system this idea that abortion, the destruction of a living, distinct life through all 9 months of pregnancy, was somehow a legal right, was an assault on the democratic process. That our states had not nationally recognized that. Our elected officials had not recognized that. That was imposed on us by the courts. In 49 years of that, we recognized we've got to strike a balance. We recognize the difficult circumstances women find themselves in, but how can we balance that with this living, distinct child that science tells us has their own blood type, has their own gender, has their own DNA, is their own separate person? How do we treat them like a second patient and balance these two things carefully and thoughtfully? And that's what we tried to do with the Life Act.
I want to ask you about this balancing in a moment, but because you brought up Roe, let's dwell there for a second. Under the Roe structure, and this is a simplification, but it is accurate, under Roe, the court set up effectively a 3-tier system of restrictions. In the first trimester, states could not restrict abortions. In the second trimester, states had broader latitude with some exceptions to restrict abortion. And in the third trimester, states had very broad latitude to restrict or prohibit, in many cases, abortion. Why did that framework not work for you?
You know, it's interesting. What Roe did, as you just said, was it allowed abortion to be legal during all 9 months of pregnancy. And there's some states that maintain that. Shocking. That a child that is viable outside of mom, that is just days from being able to be delivered, could be literally, and again, the language to describe the brutality of this is hard to even talk about, because it could literally be torn apart inside of mom, and to say that's okay legally. You know, children we spend hundreds of thousands of dollars trying to protect in neonatal ICUs or in a perinatal setting that can just be disposed of. We recognize that's just an assault on human dignity. You know, in 2012, we passed a law that limited abortion at 20 weeks. But we recognize that just as at the end of life, you know, if the marker of the end of life is that if you have a heartbeat, you're still alive, why don't we use that same common sense marker at the beginning of life? That if there's a beating heart, there's a second person. There's life that's worthy of protection. As we weighed these things out, you know, we were decried by some in the pro-life community who believe that all abortion should be illegal and that anything less than that's a sellout. You know, we were told we were sellouts because we tried to strike this balance. We just believe that the common sense of Georgians was that if there's a heartbeat, there's hope, and it's a life that's worthy of protection. As we tried to strike the balance, we felt like 20 weeks was just not enough. That children who were further along in development were worthy of full legal protection. And I think Georgians across the spectrum recognize that. We've gotten very good feedback about that. Aside from the activists that attack us on this, we feel like we struck the right balance.
Let me ask you about that, because you talk about the heartbeat. For folks who maybe aren't super familiar with this piece of legislation, the Life Act, more commonly known as the heartbeat bill, sets detection of a fetal heartbeat as the line of demarcation in when most abortions can and cannot be performed. And that typically happens at about 6 weeks of pregnancy. So to boil this down, under Georgia's heartbeat bill, most abortions after about 6 weeks of pregnancy are not legal.
Correct.
What do you say to people who look at that and think that that deadline, that timeline is just too restrictive?
Well, it's one of these things, when you look across the spectrum, you look at the options that are available to you. One of the things that was so confusing about Roe v. Wade is that it drew these arbitrary timelines. When you study the science, when you recognize that the likelihood of a child in utero being viable and carried through to term, the likelihood of miscarriage just drops off a cliff after there's a heartbeat. When the heartbeat's pregnant, you go from a 10 or 15% likelihood perhaps of miscarriage or the child not going to term to the child being 95 to 97% likely to go to term. And you have a life that has a likelihood of being carried through, and that has, again, you have a circulatory system that's starting, you've got a heartbeat, you have other markers of life that make sense to folks and that are very meaningful medically and are meaningful in other settings as being an important marker of life. We felt like, as we're trying to wrestle with what's the right balance in this, we felt like the heartbeat was medically, scientifically, and from the perspective of common sense, just a good place to try to draw that line, to strike the balance.
So not too restrictive, obviously, in your view, because you're a strong backer of this bill, right?
Correct. I mean, there was we know that life begins at conception. I mean, we know that a life is a living, distinct, whole human life beginning at conception. You have a separate, distinct person from the mother. They have their own gender that's already been established. They've got their own DNA sequence. Their blood type's already decided. It's distinct from mom. All these things have been said. They just need a safe place and nourishment to grow to a ripe old age. But the challenge is, as you weigh these things out, we do this in the context of a very diverse culture, that even though life begins at conception, and I believe is worthy of full legal protection, as you try to strike the balances, where do you draw these lines? And I think that's where, as a legislature, we recognize that in 2019 in Georgia, folks broadly believe that abortion being legal up to 20 weeks of pregnancy was just an outrage to human dignity. And where do we draw the line? How do we strike the balance? We believe that the heartbeat, the 6-week period, was the appropriate balance. And we also recognize that we needed to provide full protections for the child and for mom. There are two patients here. There are two people here that need to be cared for. And the Life Act not only prohibited abortion, but also gave mom full child support benefits, beginning at heartbeat from dad. Moms and dads were able to file for a third dependent on their taxes if they're expecting their first child. Across Georgia law, we took a holistic approach to not only protecting the child in utero, but recognizing that a new life means things to the family and those around them. And we thought it was an appropriate way to deal with it holistically, not just on a one-by-one, issue-by-issue basis.
You mentioned something that is a phrase that comes up a lot in conversations about abortion. You said you believe life begins at conception. Obviously, the heartbeat bill sets this line at about 6 weeks of pregnancy. But if life begins at conception, do you think all abortions in all cases should be illegal?
Well, we recognize that a living, distinct life at earliest development is worthy of protection. And I think the day will come where, as people wake up and realize what science tells us, I think there's going to be a consensus to move in the direction of all abortions being not legal.
Is that what you'd like to see?
I think that's the direction our culture is going. I've been very clear. I believe all abortions are wrong, but with a Life Act, we were not trying to impose Ed Setzler's view of the issue. I believe all abortions are wrong. But if we try to strike the balance, we recognize these difficult circumstances women find themselves in. We recognize we're coming after 49 years of what I see as the brutality and the violence of Roe versus Wade, where the most dangerous place for a person to be is in the womb. I mean, from 1973 through 2022, 1 in 4 conceived children were lost to abortion in our country. 1 in 4. So for every 4 children that are conceived in our country, 1 was lost to abortion. When you see that, you think about that, the culture is so distorted by the logic of Roe v. Wade over 2 generations, taking a step in the direction to try to strike the balance, to try to recognize these really difficult, legitimate circumstances women find themselves in that are very difficult, And balancing that with the basic right to life of a living, distinct, whole human child, how do we strike the balance? That's what we were trying to do. Not trying to impose one person's opinion, but try to find a place where the dignity of the unborn child is recognized, but that balances the very difficult things that we have to, that are very fact dependent, that we've got to wrestle with. That's what I think the legislature did in 2019.
If you'll permit us, let's unpack for a second, separate your personal views from where the heartbeat bill landed, because you said from a legislating perspective, you wanted to strike this balance, as you put it. But you said, too, that your personal view is that all abortion is wrong. There may be people who hear that and think of certain circumstances like incest or cases of rape. Even in those circumstances, you would believe and you would argue that abortion is inappropriate.
Well, I think the one thing we have to ask ourselves is in spite of the means of conception, no matter what the circumstances were that led to the child being born, is a child that's conceived in those tragic circumstances guilty of something. All children are equally innocent. So I think we've got to start from the recognition that all life is innocent and is worthy of an opportunity, so no matter what the means of conception is. I think the challenge we balance is when you've got a circumstance like a rape circumstance that you alluded to. The woman's liberty interest, her ability to be there and make decisions to be there is very different than a circumstance where a woman's not been raped. So even though the child is equally innocent, from a legal perspective, it's a little bit different of a balancing test. But we can never lose sight of the fact that the child who's the product of rape is just as innocent as any other child. And to turn our back on them and to say there's no interest in preserving their life is to ignore the obvious. So I think we have to weigh these things. That's why it's not a simple answer. But I think to focus only on the tragic circumstances that lead to some children being conceived and to ignore the child is to ignore half the equation. We have to balance these things carefully.
I don't want to put a label on you without you agreeing to it. I think it would be safe to say, though, you're a conservative. Is that fairly accurate?
I tend to be politically conservative.
Yeah.
And I would tell you, I tend to be one that's, I love human freedom and the opportunities that our country gives. So I don't know. I try to avoid labels because conservative means different things to different people.
That being said, fair to say, in the Republican Party, you're a conservative Republican. One of the key tenets of conservatism is small government, limited government, allowing people broad freedoms to make their own decisions, particularly about big moments in their life.
Indeed.
How do you square that with the heartbeat bill that substantially restricts a woman's ability to make a major medical and moral decision for herself?
It's interesting, in Roe versus Wade in 1973, it was a 7-2 opinion in the United States Supreme Court. 116 years earlier, that exact same United States Supreme Court, by a 7-2 opinion in Dred Scott v. Sanford, said that Dred Scott was not a person. Dred Scott was just the property of the Sanford family. And then even when he fled a slave state to a free state, he was still the property of the family. That was a personhood question in 1856, 1857. The question of Roe versus Wade is a question of personhood. Is the child in utero a living, distinct human person that's worthy of legal protection? In fact, the Roe court even said that if any state establishes the personhood of the unborn child very clearly, the whole logic of Roe versus Wade collapses because they get the protection of the 14th Amendment of the United States Constitution. Conservatives recognize the job of government is to preserve liberty, preserve human rights. The first thing a government's job to do is to preserve human rights. And the issue of preserving the sanctity of human life is job one. As our Declaration of Independence says, we hold these truths to be self-evident, and it goes on. And among these are life, liberty, and the pursuit of happiness. That the preservation of life is the basic function of government. And preserving the human rights of the living, distinct human child is a higher order issue than saying you get to do what you want in a free society. We're balancing these, we have to balance these different interests. But the preservation of life and human rights is really the first rule of government, and conservatives don't lose sight of that.
The heartbeat bill was very contentious as it moved through the General Assembly. It passed, and this was back in 2019. Roe was still a law of the land at that time. It wasn't until 2022 when the Dobbs decision unwound Roe that the protections that Roe instituted fell back. Do you think, and where I'm going with this is that in 2019, when state lawmakers were voting on the heartbeat bill, they were voting on a piece of legislation that, even if passed, would not go into effect as long as Roe was the precedent guiding the courts across the country. Do you think that if lawmakers knew that Roe was going to fall in 2019, they still would have voted to pass the heartbeat bill?
Without a doubt, yes. In fact, I think the heartbeat bill, I think we recognized, which referred to the heartbeit bill, the Living Infants Fairness and Equality Act, did something that no law in the nation had done before. You know, some states kind of, in their actions, kind of waved their fist and challenged Roe versus Wade. They in sort of rebellion against the Roe framework. The Living Infants Fairness and Equality Act was crafted specifically to answer Roe versus Wade. As I alluded to earlier, you know, Roe says that if any state ever establishes the personhood of the unborn child, the Roe logic collapses because they get equal protections under our laws. The Living Infants Fairness and Equality Act, you know, dealt with a whole host of things in addition to abortion to, again, as I talked about, give moms, you know, child support from dad beginning at, you know, as soon as you have a detectable heartbeat, dad's paying child support. Not when the child's born, but during, you know, during mom's pregnancy. Gives parents full tax exemptions having a family member. You know, one of the outgrowths and implications of the Life Act was, you know, pregnant moms ride in the HOV lane because there's now two people in the car. We recognize in a hospital setting, in a medical setting, there's really two patients. And the Life Act recognized that legally. And it recognized that by answering Roe versus Wade, we were going to satisfy the conditions of Roe. That if any state established that personhood legally, then the abortion logic collapsed. We knew that even without the Dobbs opinion, that the Life Act was going to create the circumstance that would persist beyond Roe versus Wade. We had met with legal scholars. We had thought about this very, very carefully, and it was intended for that purpose. And I think our members recognize that.
I want to ask you just a last couple questions here. You obviously have very strong beliefs on this topic, and you're passionate about it. The question of abortion is one that gets at issues of morality and faith and philosophy and medicine. What do you say to people who might hear your stance on this and think that this is a much more complicated and nuanced topic than maybe your view and your stance belies?
Well, it's interesting. If you go back and listen to the debate on this and listen to everything I said publicly, and I had an opportunity to talk to the public quite a lot on this, in committees, on the floor, in interviews, we relied really on three things for this whole discussion. It was silence, law, and common sense. You know, this was not pushed forward as some religious matter. Science tells us that when a child's conceived, they are living distinct from their mother. It tells us that when the child has a heartbeat, there's a very, very low likelihood of a subsequent miscarriage. They're going to be carried through to term, and they're living distinct from their moms. They have their own circulatory system. They have a heartbeat. They've got their own blood type, their own DNA, their own genders established. They're clearly distinct from their mother.
I don't mean to interrupt, but just to be real.
Medical science treats them as a separate patient. So science tells us that.
Well, there'll be people who will dispute that, though, and put that point of fetal viability substantially later in the course of a woman's pregnancy than 6 weeks.
Correct. They'll play the name game. Because their definition of fetal viability is when you can pull the child outside the mom. That was part of the logic of Roe versus Wade. If you can pull the child outside of mom and they can live distinct from the mom, then they become a person. That's falsehood. You know, you think about children that are 6 months old. 6-month-old children cannot be released to a state of nature and take care of themselves. They're still totally dependent on mom, even mom and dad, others, even though they're outside of mom's belly. So there's a lot of definitional play that you see here. But science tells us the child is living distinct from mom. Law, the legal framework. You know, when you look across the Western legal tradition, it's not just folks in our modern era that tell us this is wrong. It was very interesting during the Life Act debate on the floor of the House. One of the opponents of the Life Act got in the well and said, "You're doing harm. The Hippocratic Oath says do no harm." You know what the third sentence of the Hippocratic Oath is? The 3rd century pagan Greeks recognized this. The Hippocratic Oath, the 3rd sentence says, I will give no woman a pessary, which is a chemical, to induce or cause an abortion. The pagan Greeks in the 3rd century BC recognized that abortion was an assault on human dignity and was outside the realm of medicine. Our Western legal tradition recognizes that abortion is always wrong. And it's only really since the early 20th century when the progressive movement seeking to impose abortion on minority communities to try to limit, as part of their eugenic population control agenda, that abortion become
I think, I just want to be clear here, I think there'd be a lot of people who would hear what you just said and push back pretty firmly on the claim that progressives were involved in a plan of eugenics.
Oh, listen, go check it out. Listen, Margaret Sanger, the founder of Planned Parenthood, had what was called the Negro Project in the 1920s and 30s. And her Negro Project said, you know what? They recognized that Northeastern liberals could not convince black families to take on abortion. But they recognized if you could get the black pastors and have them sell abortion as this means, this tool of prosperity, have fewer kids so each kid can thrive and do better, that their eugenic plan, this belief system could be pushed on the black community. That's exactly what happened. I mean, Margaret Sanger was a radical, race-hating eugenicist. It's interesting, what you've seen in the last couple of years, you've even begun to see folks on the left start to attack Margaret Sanger because of her history. They can't deny it. It's sickening. You know, I don't talk about these things much, but when it's raised, the history of abortion is a dark, dark history that really arises out of early 20th century eugenics. And it's ugly to see. And I can tell you the left tries to keep it hidden, but when you unpack this and see the history of this, this is not abortion was not brought to America as a way to make people better. It has a really dark history. So it's unfortunate when you follow the legal history of this, and then you see the fact that really through, it wasn't until the 1960s that any states even began to legalize abortion. The legal history really lays throughout the whole Western legal tradition is consistent with abortion being prohibited. And we're walking in step with that tradition, trying to strike the balance. But there's just a relatively short time in history that's been legal and been seen as anything other than wrong. And then lastly, common sense. You know, we talk about science, law, common sense. If you take a picture, an ultrasound, a 4D ultrasound of a child that's 8 or 10 weeks along, and you show that 4D ultrasound to a class of kindergartners, put it on a TV screen, you ask the kindergartners, what are you looking at? They're going to look at it and they're going to say, that's a baby. They get it. They understand that. The common sense of your grandma, the common sense of your kindergartner recognizes that a living, distinct life inside of mother is a life. And that there's two patients here. And that when we have two patients, we should treat them as two patients. And it's an issue of the dignity of the most helpless member of our human community, the living, distinct child living inside of mom, that the Life Act recognizes should be worthy of legal protection.
Let me ask you about a case that made national news recently, and this is the case of a woman here in Metro Atlanta named Adriana Smith. I know you're familiar with this case. Now, according to her mother, April Newkirk, Adriana Smith was pregnant. She suffered a terrible medical event that led her to become brain dead. And according to Adriana Smith's mother, the hospital in Metro Atlanta that was treating her said that Smith had to remain on life support because she was pregnant, had to stay on life support until the baby was delivered, and had to be that way because Georgia's heartbeat bill, also known as the Life Act, gave the doctors there no choice. Yeah. Now, if that is how that played out, according to the mother, is that an accurate interpretation of what Georgia's heartbeat bill demands?
Let me start by saying the Adriana Smith circumstance was just tragic. You know, our heart goes out to Adriana and her family. It was sickening to me to see that people on the political left rushed to the closest microphone they could find to talk about this and to point fingers and say, "Oh my gosh, this is a legal travesty," to try to secure political points out of this. It's been almost unrelenting to see the political left callous to the circumstances and the pain of this family to try to publicize this issue. Now, having said that, when you think about this, what you saw in the Adriana Smith case is medical science. Medical practitioners recognizing that that in spite of the tragic circumstances of Adriana Smith that they recognized could not be saved, that they had two patients. There are two patients here. When you look at the medical literature, you study medical journals, the judges in Emory recognized that of the 35 documented cases in our medical literature of mothers who were comatose in similar circumstances to Adriana, 27 of the 35 children were delivered, carried to term, and were living otherwise healthy lives. So they recognized, and even one case in Germany where the child was 9 weeks along, was able to be, mom was able to be kept alive long enough that this child could be delivered, that even though mom tragically couldn't be saved, the child could be. And medical science showed this. The doctors recognized there's two patients here. And the Life Act does recognize that when you look at moms and children in utero, that they be treated as two patients. There's been a lot of extreme examples that have been falsely leveled in the Life Act by its opponents. But what it does do is it recognizes there are two patients to be cared for. And I think when you consider the delicateness of these circumstances and the humanity of the child in utero. We've seen these pictures of children that were 20, 21 weeks along that are being operated on in utero. You've even seen the picture where the little child reaches its hand outside of the uterus of the mother and grabs the doctor's finger that's operating on them. You see the delicateness and the reality of the life in utero. The Adriana Smith case is a tragedy for a mom who was lost. But the beauty of it is doctors recognized there were two patients that were worthy of care, and they did right by Chance, her son, and who I have high hopes for, and I think we all do. But it really became a matter of when there's a tragic circumstance that's happening to mom, there's a child in utero, is there one patient or is there two? And I think this is an example of what we recognize as tragic as the loss of mom is. Thankfully, there are two patients, and the medical system recognized that.
And just to put a really fine point on it, you think that the doctors in this case correctly interpreted Georgia's heartbeat bill to carry out the procedures that they did here?
There are two patients, correct. The Attorney General is very clear. There's not a circumstance where the doctors, if they had decided to pull the plug early on Adriana's life at the behest of family, the removal of child support, which would have led to the demise of the child, would not have led to a criminal conviction of the doctors. But the real issue is there's two patients. That's the component of it. And I think that's been misportrayed by some of the folks who are seeking to gain politically by attacking the Life Act, because I don't think they really understand what it does.
It sounds, and you brought up the Attorney General Chris Carr's statement on this. I'm glad you did, because I wanted to ask you about it. It sounds a little bit like what you're saying is the doctors in this case got the spirit of the law correct, but the actual text of the law maybe says something slightly different, or at least the Attorney General interprets it that way here. And you might disagree. I just want to read what AG Chris Carr's office said, and this is a quote from his spokeswoman. There is nothing in the Life Act that requires medical professionals to keep a woman on life support after brain death. Removing life support is not an action with the purpose to terminate a pregnancy. That was the core of the Attorney General's office's statement. So does the heartbeat bill's language need to be clarified to make this kind of circumstance a little more clear for doctors and medical providers to know how to follow it?
I think what the doctors and medical providers were doing is they were following their medical standard of care. And they do have a legal duty to follow a medical standard of care. When you've got 35 cases documented in the medical literature in which mothers in largely comatose circumstances were able to carry a child to term 27 of 35 times, they recognized it was their duty of care to treat this like to recognize there's two patients. I think that's what they were acting on. I think the Life Act raises the attention. It certainly gives the opponents of life, those that would say Chance's life should just be discarded. and should be treated as garbage. And those that were arguing that the mother should, because the mother couldn't be saved, the child should be forgotten about. I think it's callous and sad. I think the doctors were acting within the medical standard of care. And medical standards today, with modern medical science, recognizes that in the supermajority of cases, these children can be saved and if brought to term. I think that's what the doctors were acting on.
We've covered a lot of ground here, Senator, and I appreciate your time. I think maybe a good place to end would be this, and we've touched on it throughout our conversation, but I think it's worth putting directly to you. Obviously, you're a big supporter of Georgia's Life Act. You brought it through the General Assembly. You've been a vocal supporter of it for years. That's no secret. There are going to be other people who have very different views on abortion and on reproductive rights. I can imagine somebody watching this interview right now, following this issue, a woman in Georgia who is deeply troubled by what the heartbeat bill does and her ability to choose that the heartbeat bill now drastically prohibits. To that woman, to her concerns, what would you say?
Appreciate the question. The Living Infants Fairness and Equality Act simply seeks to recognize that the most fragile member of our human community is a living, distinct child living inside of their moms. The circumstances we're dealing with here is not just one of an individual choice. If this was a matter of a medical procedure removing a growth or a tumor from inside of a mother, I'd be fighting on the front lines to make sure that no one could stop the medical freedom of a person from doing that. Now, I've got a pretty strong record fighting for individual rights and liberties and helping, defending regular folks against the big system, right? But we can't ignore there's a living, distinct child. I would say, think about the fragile child inside of mom. That the Life Act seeks to recognize the very difficult circumstances women find themselves in, not to ignore that. But when there's a second person, there's a second child here, aren't they worthy of protection? That we don't allow that moms, 2 days after a child's born, as mom's driving home from the hospital, if mom has buyer's remorse and wants to ditch her child, we don't let that happen. That's infanticide. What's the real difference between a child that's 2 days old outside of mom and a child that's 2 days from being born? Maybe the early labor pains are getting started, but child's inside of mom. Is there a fundamental difference? I mean, I argue that science tells you there's not. What about the child that's 7 months along? What about the child that's 5 months along? When a child is living in distinct inside their mother, they are a second patient. And what is culture called to do to strike that balance? It's not just a one-person question. If it's a one-person question, it's an easy question. But when you recognize there's a second patient there, we as lawmakers protect the helpless that can't protect themselves, and we balance those against liberty interests all the time. How do we strike that balance? There may be those who said, Dad, I agree with what you're doing. I didn't think 6 weeks was the right line. I think it should be 10 weeks. Europe is 10 weeks, or this country is 13 weeks, or here is there's abortion's always wrong. You wouldn't believe the people who've come to me and said, Setzler, you're a sellout because you didn't ban all abortions. But when you think about the fact that when a child is 6 weeks along, they're 95+% likely to be born. They are distinct from their mothers. As we try to balance these things, we honestly thought through these things very carefully. We care very much about these difficult circumstances. The year after we passed the Life Act, we passed the Maternity Supportive Housing Act that deregulated kindness and allowed people to open their homes to pregnant moms without regulation of local governments and state agencies that regulate otherwise maternity homes. We cover moms. You don't have to get a pregnancy test in Georgia. We cover you as a pregnant mom just by going in and declaring that you're pregnant and you want services all the way through 1 year postpartum. We've tried to wrap ourselves, wrap supports around mothers in these very, very difficult circumstances because we do care about the mom. But it's not just a one-person equation. There's a second person here we're trying to balance and protect the life of, and it's something we're very thoughtful about, we're not callous about, and we're not doing it for political gain. I mean, it's easier to ignore this and to run from this issue. There's no political gain in trying to protect the unborn children in our culture. But it's the reason that when you recognize the purpose of government is to protect the human rights of the helpless, it's an important thing not just to try to pass and support and protect, but to communicate on and to move our culture in a place where the callousness of 49 years of Roe versus Wade, which is really an outlier in the Western legal tradition, can be undone, and we can put things back in step with balance as they should be.
State Senator Ed Setzler, thanks very much.
Appreciate your time.
State Senator Setzler mentioned Planned Parenthood in that interview. We reached out to the organization to see if they had a response to share. This is what Caitlin Darby, a spokesperson for Planned Parenthood, said. The Negro Project had nothing to do with abortions, as Setzler says. That's inaccurate. Sanger was not a proponent of abortion for anyone, but instead focused on birth control. We promote affordable, quality care for everyone and the right for all people to make choices that are best for them.